Right, so Holmes is a very well-known figure. You think of him as this aristocratic Boston Brahmin who spent 30 years in the Supreme Court developing some very important doctrines that we don't generally talk about in IP, right? First Amendment stuff, regulatory takings, his Lautner dissent, 3 generations of imbeciles are enough. Less well known, he's a Civil War veteran. He was wounded 3 times, that very much left an indelible mark on all facets of his life, including his jurisprudence. Not sold on the law as a vocation at first, sort of thinking he might become a philosopher, sort of joked about being kicked into the law by his father, who was famous by his own rights for being a doctor and author, but he did take the law seriously and made it his own profession. And he spent a lot of time in his early years of private practice writing scholarly articles that culminated in the Common Law, sort of famous 1881 book. And then when he was also in the Massachusetts Supreme Judicial Court, which he served on for 20 years, Chief Justice the last couple of years there. And then he was nominated to the U.S. Supreme Court in 1902 by Theodore Roosevelt. They later had a falling out due to his going against the grain in some antitrust cases. At the same time that Holmes was coming of age professionally and personally, the post-Civil War U.S. Sort of was undergoing a period of extreme innovation, both technological innovation and legal innovation, and Holmes played a large role in some of that legal innovation as the law in the late 19th century had to adapt to the rise of the corporate entity, embrace new ways of doing business and contracting, and this consumer class was developing as we had consumers of manufactured goods and all that that implied in society. Patents were being filed at a record pace. Technology appeared to be improving the lives of people everywhere, and Holmes was part of that generation of lawyers who participated in this legal innovation and recognized saliently the need for law to adapt to changing times. So what were Holmes's views on patent law? So Holmes was a common law judge. That was his background in private practice. That was his experience as a state justice. And so due to federal question jurisdiction, he likely didn't see a patent case until he got to the Supreme Court. He wrote the majority in a very small number, a handful of what I might call nuts and bolts patent law cases. These are cases involving infringement disputes that would not arise today because of the consolidation of appellate review through the federal circuit. But these allowed Holmes to consider some very narrow questions of infringement, invalidity, and interpreting license terms, which is probably what he preferred the most, right, involving contracts and not actual patent questions. In these cases, he leans toward very narrow constructions of patent claims and disclosures. He focuses his efforts on the public disclosure rationale for patenting as the primary goal of the patent system. Probably conventional in his time, although obviously modern day theory talks more about commercialization and innovation rather than public disclosure incentives. He pushes for patents to be clearer, more certain, and not capturing things already in the public domain, in contrast to some of the other folks on the court at that time who really focused on encouraging these nascent technologies and having broad patent rights be very high rewards for advancing technology. The most well-known of his nuts and bolt cases, for teachers of patent law at least, is Alexander Milburn versus Davis Bournonville, where Holmes held that an earlier filed but later issued patent application could serve as prior art to an application, even though that pending patent wasn't kept secret. It's an extremely short opinion, but it says quite a bit in the shortness. He talks a little bit about the statute, does some statutory interpretation. We've since codified his holding here in old section 102E and new section 102A2 and 102B2. But he really focused on this idea that the statute doesn't necessarily tell us whether these secret applications are public disclosures, but we all think they should be, and so I'm just going to create a rule that says that, right? It's a very important holding, I think, in terms of statutory interpretation. He focuses again on public disclosure, that the patent applicant in the first instance had done all that he could do, and USPTO policy to keep the stuff secret really shouldn't unravel the fact that this second guy is not the first inventor. The second category of cases, of non-nuts and bolts cases, feature patents as component parts. Antitrust cases, property right cases, contracts cases. So Winslow is one example of these where Holmes approved of a combination of patent holding companies, what we would now call a patent pool. And Holmes talks quite a bit about not worrying about monopolies so much. And so he thinks that because patents are being held over the machines in the first place, the combination of patent owners into one consolidated group shouldn't bother us all that much. And he says, quote, "The exclusion of competitors from the use of machines is of the very essence of the right conferred by the patents," end quote. For Holmes, patents were very much property. They were statutory property, not common law property, but property nonetheless. The same theme is tracked in his dissents in motion picture patents and an antitrust case, Dr. Miles, where he talks about whether patent owners can tie unpatented goods to patented goods using the threat of patent infringement remedies. And motion picture patents is sort of a case that has its own long and fraught history involving overruling an old case in A.B. Dick. So Holmes, in this dissent in motion picture patents, talks quite a bit about patent owners being able to extend monopolies due to the rights they obtain, and that the majority is sort of wrong in grasping for public policy to sort of unravel some of the arrangements that patent owners were doing in some of these contracts. He ties the patent owner's right as an ordinary incident of its property ownership, again, this property language. He dissents in Dr. Miles' an antitrust case, and talks a bit about the most enlightened judicial policy is to let people manage their own business in their own way, unless the ground for interference is very clear. We exaggerate the value and importance of the public competition in the production and distribution of an article as fixing a fair price, end quote. And so Holmes is sort of recognizing that patents don't necessarily require focus on monopolization per se, but in finding some practices illegal, as we might see under the common law. He has one repair reconstruction case called Hire Duplicator, where he sort of talks about the purchaser of goods having some common sense in the bargain of the purchase, that the machine owner would then be able to replace replaceable parts without worrying about liability to the patent owner. There were a handful of other cases involving jurisdiction, which are pretty well known, and then some odd one-off sort of problems involving postmasters and state taxes. So what can we learn from Holmes's patent and patent-related opinions? Taken merely at face value, not a ton, right? Not a lot of data. It's a limited set of opinions. I don't know that Holmes cared so much about patents in the first place. He sort of didn't care much about a lot of things, I think. But looking at his patent works in context, particularly that historical era in which he was writing, practicing law and judging, I think we might find some hidden perspectives that could frame current patent debates. So two themes that I believe Holmes weaves through his cases that are sort of worth exploring in the context of patent law. One's a general theme, and the other is more patent specific. And the first general theme is that all law, including patent law, including statutory law, can be treated like common law. And by that I mean Holmes focuses on the dispute at hand between private parties, trusts that the general principles will out themselves over time in a collection of similar cases, decide the specific case first, and the general principle will follow. And we take this view, you can kind of focus less on getting every case exactly right on the principles, maybe get each case about right, and on average have an adequate set of laws. And so I think the Roberts Court in the past decade, as it's sort of seen the steady ramp up of patent cases, it sort of talks about public interest, competition, the public domain, encouraging invention as potential counterbalances to those very valuable exclusive private rights that we think of when we think of patents. Holmes, I think, would sort of be worried by this waffling over what patent statutes sort of intend to do and the resulting muddying of what they actually do with uncertain opinions. He would certainly appreciate the complexity involved in today's cases, but for Holmes, complex cases are not a challenge. You simply break them down to easy cases using things that you know, and then have future generations sort of know what they can do. The second theme in Holmes's patent jurisprudence is what I call cautious maximalism, although I'm looking for a less bulky terminology if anyone has any. Patent maximalism light, I don't know. So there's a divide today, we heard a little bit more about it this morning, between patent minimalists and patent maximalists, and everyone's kind of saying that their position is right, and everyone's doing a bunch of empirical works that are proving that their position is right. And I think that Holmes's views on the narrow disclosures, the need for clear claims, sort of falls somewhere in between, but more on the property side. He operates in a sphere of private law or common law really set within a statutory regime, and he has this laissez-faire attitude toward the business practices of patent owners that allow patent owners to protect things with a property rule with limits. And so I think that we see some of this in some of the cases from this past era. Warner, Jenkinson, and Festo, Nautilus, KSR, they're all kind of Holmesian in some degree, and that we have a doctrine of equivalence, but it's limited, right? We want to be very cautious about how it's applied. We grant patents on small improvements, but we want to make sure these small advances are inventive enough. We want our disclosures to be robust enough to tell the public about the invention, and that will help us make patentability decisions. We want them to limit the private rights that were granted. We might contrast these sort of Holmesian opinions with cases like Bilski and Alice, which seem to kind of start with the notion that these patents seem bad to us intuitively, and then work backward and try to create some kind of legal doctrine that handles software and business methods and abstract ideas in all cases. We get not a lot of clear guidance, a lot of retreading of old ground without legal innovation, and Holmes might have preferred to think more about what these statutory property rights look like, how are they tied to the goals of patent law, and what cost will it be to eliminate the types of things that we are pushing to eliminate. How can we get it right? How can we have some kind of cautious maximalism? So it might make sense to remind both the Supreme Court and the Federal Circuit that Holmes had some ideas about how patents fit into a massively changing society that increasingly depends on technological advancement for the welfare of the public and the growth of the economy. One theme might be to get it about right and sort of work from there. Consider whether you're willing to pay the price in that decision. And then the second theme might be to maximize cautiously and open to limits. So that's it for now, and I will take questions. Sorry, I just ran through that really quickly. Light or fair? Yes.
So I apologize if I walked in this mechanism a minute or two late, but so you talk about his patent opinions, and you say that he didn't seem to have so much enthusiasm for patents as a rule. How do you compare that to his enthusiasm for, say, copyright and license, for instance?
I read Bleistein. I see it less as enthusiasm for copyright law in general, and more enthusiasm for his. He liked art quite a bit. And so less enthusiasm for copyright and more of a general interest in things like art and the advertisements that are available there. I think Bleistein allowed him to sort of say what he thought original meant in the 1909 Act. And that to him was almost everything, right? Statutory interpretation, figuring out what this kind of says. But an art lover in his personal life, right. Not necessarily a technology lover.
Well, an art lover was the father of the poet.
Right, yeah.
One other case, I'm sorry, not apologize. The other one is, what about his concurrence in Whitesmith's The Apollo?
Yeah, the player piano case.
Yeah, which is sort of not a patent case, but sort of closer, maybe a little closer to that.
Very close. So I'm considering the other IP cases now, right? So Whitesmith is another good statutory interpretation case where we don't really know what to do with some of this fancy technology that sort of comes out without regard to sort of how we've drafted our statutes. And so, I think his thoughts are very important on that. And I think it's not so dissimilar from Alexander Milburn in the patent space, where he's saying our statute doesn't really cover what's going on here. And so I think the best path is X, as long as we're willing to pay the price of what X does for future generations. Yeah, here, and then back to Jeremy.
So one question I have is, did Holmes get anything, tremendously wrong, do you think? Or, what cautionary tales are there potentially?
And INS, yeah. So INS is in the paper also. Hard to say wrong. I think that he wasn't really looking at patent law the way that we're looking at it now. And I think one thing that sort of makes him similar to some of the folks on the court today is that he's a little bit worried about saying too much about patent law because he doesn't know a lot about patent law. Some might say that people are fine saying lots of things in areas that they don't know, right? But I think that he was cautious in that way, knew a lot about property and contracts, and thought more in terms of those things. So I think some might say that his dissent in motion picture patents is wrong, right? That we should continue down the motion picture patents path. I don't know that I necessarily agree with that, or that everyone in this room agrees with it. Everyone might think he's right there. I think more in the antitrust space, we've sort of found him wrongish in some places, because he sort of saw antitrust differently than I think our modern view of antitrust is, right? He didn't think about it from a price theory perspective. He thought about it from what he defined as competition, which for him, it was fine if we created huge patent pools. It's fine if we created conglomerations. If you couldn't afford the teapot, don't buy the patented teapot, right? I don't know that that's wrong. I think it sort of illustrates that both camps, maximalists and minimalists, are both right in some sense. We just kind of have to decide where our law is going to go. Yeah, Jeremy.
I apologize also, I came in a little late, but there's a trade secrets case that Holmes wrote called Maximalism where he vehemently denies that there's any property component to trade secrets. So I wonder how you reconcile it. Is it sort of the formalism that patents is statutory right and trade secrets is some of this common law right, unclear origins, but it's just language is very anti-property in that case. So I wonder how you can reconcile that.
I think that's exactly it. So he often describes as a patents as property in the most abstract sense possible, but property nonetheless. And I think he derives from that the statutory grant, right? We're granting patents. We are setting the boundaries for these property rights in this exact way through the Patent Act. And for him, that's enough. That's the same as having sort of a common law property regime for trade secrets, where we don't have a long-standing sort of common law understanding of them. He's less clear about what the boundaries look like, right? And so that, to him, may be something very different than the statutory property, as he described it, of patents.
2 minutes.
And copyrights, too.
2 minutes.
Yeah. Other questions? Well, thank you very much.